We have about half an hour left for just a general plenary discussion. So, I mean, I think we could begin maybe by just having a sort of asking questions of or making comments about the remarks we just heard. Does anyone have any questions or comments? Sylvia?
Yeah, hi. Thank you to all. I really continue to be amazed how we can keep meeting at conferences and workshops and keep talking about this topic and still have new things to say. So that's wonderful. And I really learned a lot from all of the commentators. I had some questions that that sprung to mind listening to Yaniv, but they could also be relevant to the other commentators. And looking at the four elements, Yaniv, that you try to extract very helpfully about why, why Asia, why the basic structure doctrine in Asia and the way, why has it been developed in the way in which it has been. And for example, you talk about political democratic culture, amendment culture, and I thought, shouldn't we add judicial culture as well, and the culture of courts and judiciary and also the judicial attitudes that we encounter, especially vis-a-vis other branches, but also the self-understanding of the courts, of their own role, of the role of judicial review. And there are so many things that spring to mind as potentially relevant there, from inherited colonial legacies and the UK influence to American influence, etc. And of course, these cultures change over time as well. And I think this is where I'm really sorry not to have listened to the conversations yesterday, but these things and these doctrines also develop over time and have evolved. And we've moved in several jurisdictions from initial resistance to gradual openness to outright adoption. In some instances, like in Sri Lanka, still resistance. In others, like in Malaysia and possibly Singapore, more openness, etc. So, two things, I guess, there. One, the influence of judicial culture, and the other, the temporal element, the fact that we're not actually dealing with, even one jurisdiction as a monolith, but at different points in time. And the other is, reflecting on the previous panel discussion as well, where the point about informal amendments was brought up. And it's fascinating to me that, we talk about informal amendment, but I think sometimes we mean different things when we use that term. So for example, to go back to Yaniv's presentation, where you talked about the flexibility of the amendment process and how that influences whether a basic structure doctrine arises or not. I guess, whether it's necessary or not will also depend on whether you think amendment via judicial review, constitutional review, as arguably has happened in the US, is desirable or acceptable, or whether you have in mind, for instance, informal amendments, as we talk about, for example, in some countries in Europe and elsewhere as well, as sort of sub-constitutional amendments or abusive legislation that de facto amounts to amendment but isn't really recognized as such, and is also done so on purpose to avoid constitutional scrutiny. So that's, I don't even know what the comment there is, or what the question rather is, but it is a comment to say that I think this question of informal amendments and how they arise and what we mean by it, can be mined further for more insights. And I'll stop there. Thank you.
Yaniv?
Right, thank you very much, Rehan, and thank you, Sylvia. I'll try to answer Sylvia, and then I have maybe two questions or comments to regarding the panel participants. So Sylvia, the idea of judicial culture attitude is interesting. I need to think about it more. I mean, obviously, it's not something rooted in judicial culture. I mean, we've seen Commonwealth countries, taking Dicey and throwing him aside. So I'm not sure about that. I certainly agree that there is this sense of maybe, let's say, peer pressure, or when you see that other courts in the region, in the area, have managed to do these certain things, maybe you are then encouraged really to execute your authority this authority to the maximum when you see other courts around the world. But I certainly agree that we see a change in judicial approach. So the Malaysia and Singapore, of course, are the obvious examples here, originally saying, no, there is no such thing, and then gradually trying to be more accepting for this idea. But I think that the point of judicial culture attitude, I think it is related to the other features, in the sense that in a jurisdiction where you have all the four, when you don't have the four components that I said, if you have supranational observation, and the constitution is very extremely rigid, and no strong dominance of a party or executive, and there is a culture, the judges would not get the opportunity to deal with this issue. It would not arrive to them. So you need to get to this moment where there is an abuse, a political abuse or something, that then necessitates the court to intervene or to decide what kind of approach it wants to take. So I think that's maybe a deeper argument. As for judicial amendment or informal amendments, well, I certainly agree. I don't doubt the fact that certain interpretations of the court can be regarded as informal amendments, as a dramatic changes to the text or to the meaning of the Constitution, without a doubt. I do think, and I haven't mentioned that, but this is, I think, important to note, that just as the amendment power is regarded as a limited organ, all the more so the court, which is a constituted organ, must be regarded as limited. So informal amendment is acceptable and is a normal way of life, of constitutional development, but as long as the court does not revolutionizes those various basic principles or features that are regarded as unamendable. So just as the politicians cannot touch unamendable values, so does the judges, to my mind, at least. So the court is also inherently limited in its scope of interpretation. I just want to say, well, maybe if I'm already answering Sylvia, so just one or two comments. One comment is, Sylvia mentioned that courts might hesitate before invalidating amendments due to the fear of backlashes or overrides. That is correct, but I think there's another side to this coin. In a recent piece with Nicola Tomasini and Pedro Riseto, we focus on Brazil, and we show how when you have the power to review amendments, you are less afraid than backlashes or overrides, because you can then deal with them. So that's one point. The second point, you've mentioned judicial independence and abuse, how the courts in India and Bangladesh have misused, let's say, the doctrine to shield their own appointment mechanism to protect their own judicial independence. Rehan also has a nice, I think, one or even two, maybe even three articles just on that point. And I want to say, originally I thought, like the argument you've just mentioned, that perhaps when it comes to the judicial structure, judicial appointments, the court should be extremely restrained and not deal with it as part of the basic structure doctrine, because it's something like a self-interest, right? I have to admit that in the last 5 years, when we see the era of democratic erosion and populist constitutionalism, where the first thing that the politicians try to do is to capture the court, to undermine the court. And once you capture the court, it's very easy to destroy the other parts of the Constitution. I think that perhaps in order to protect the core of the Constitution, courts should be extremely militant or extremely activist when it comes to judicial appointments and judicial independence. Because without protecting judicial independence, the other constitutional guarantees are useless. Once you capture the court, it doesn't matter what the other parts of the Constitution say. So we must protect our courts independent. And I'll just end with something that Andrew asked. Andrew said about unwritten constitution. So I just want to maybe to recall. I don't know if older people are familiar, but I just took two examples while he was talking. So Lord Stein in the Jackson case says the following. He says, in certain extraordinary cases that involve attempts to completely cancel judicial review or the ordinary role of courts, the Supreme Court would have to examine whether this is a constitutional fundamental that even the sovereign parliament cannot change. This is UK, yeah, dicey. And also in New Zealand, Sir Robin Cook gave a talk, and he said the following in one of his papers. He said, modern common law is based upon two unchangeable principles, the action of a democratic legislator and the action of independent courts. If there would be a law that would change these principles dramatically, courts would be obliged to act. So even in these two countries, New Zealand and UK, various judges have opined that there may be limits to what the parliament can do. I'll stop here, although I have something about Israel that Andrew asked, but maybe later if we'll have time.
Thanks, Yanni. Does anyone else want to come in? Son, do you have a question or a comment?
We have one participant raised their hand.
Yes, I've asked them to actually text me the question because I'm not sure how we can unmute them. So we'll wait for that. Just a quick comment in response to what Yanni was saying. I think this point about the kind of whether judiciaries are acting in self-interest or not, I think is an interesting one, right? And it's come up now in a few different contexts. It came up in India and Bangladesh, and then earlier today in Malaysia. And it's a really tricky one, right? Because on the one hand, you know, as Yanni said, you know, like we can see around the world with democratic regression, et cetera, you don't want the courts to be captured. On the other hand, you know, you are getting to a level of juristocracy in some of these places that's really unhealthy for democracy. I mean, in India, this is totally clear. I think Tarun Kaitan and others have shown this. I would argue the same is true in Bangladesh, though maybe Ridwan would disagree. And so I'm not sure what the solution is, right? I mean, partly is that you have a very dysfunctional political system, so it necessitates a certain amount of judicial activism. But it's very difficult to police exactly when they do this. But it does seem to be a trend, and perhaps this is something that can go in the book, so maybe we can put this in the introduction. My sense is that the basic structure doctrine increasingly is being used for judicial independence. And I'm not sure that that's a good thing, right? So it's a really interesting one. Because I think, I don't know, but the earlier cases, at least in Asia, seem to be about a range of things. But these days, India, Bangladesh, Pakistan salient features, it's all about judicial appointments, judicial removals. The Malaysian case is about sort of the judicial power and whether sort of the secular courts have power over the Sharia courts. So there's something really interesting going on there. Pojan Yap and I have a paper out about the Bangladesh case, and we call it judicial self-dealing, which I think describes what the court's doing, but it doesn't actually describe the motivations for it, right? And I'm not sure how we get to the motivations. Perhaps we need to do some more kind of qualitative interviews or research or something to go beyond the cases, because I don't think the cases actually tell us exactly what these judges are thinking, and I think it's extremely contextual. You know, I think Kem Tong's paper brings this out very well. Like, unless you understand the very specific dynamics of Thai politics, it's very difficult to make a judgment on what the Constitutional Court is doing. And I think that's true in all these places, right? The politics are also becoming quite complicated, which makes it difficult to then make a judgment on the law. So those are my comments. Yeah, Yanni, go ahead, and then I'm going to read out.
Just to follow up, your observation is, I think, extremely on spot. And this trend that you've just mentioned about Asia occurs in other countries as well. So recent cases in Colombia, the one I mentioned in Slovakia, they're all examples where the court is trying to protect himself. Now, obviously, this has very negative effects. Often could be a very bad thing, but what I've just argued is, if the aim eventually is to protect the constitutional core, it might be a necessary evil. Perhaps, I don't know.
Sylvia, please.
Yeah, I'll jump in quickly and say that I agree with you both, but I think in all of these cases, the case that judicial independence is at stake when these changes are being introduced still needs to be made. And, you know, it's not a convincing case in many of the ones that we're discussing now, right, to put it diplomatically. So and for me, this is also an instance where us as comparative constitutional scholars can help. I think, Rehan, that's why I love your pieces on this with respect to India, because if you look comparatively, you know that there is actually greater diversity in terms of judicial councils, judicial appointments, different variations and permutations of political involvement in the process. So the argument that as soon as you remove judicial supremacy, you attack judicial independence, that is an argument that needs to be made in each individual context. And I think, why I look at these cases as, as worrisome is because the case wasn't made. And in addition, just drawing on European examples, part of the problem within Europe is also that there has been sort of a standardization of design options, partially promoted by the Venice Commission, which in some instances has promoted these sort of judicial councils, judicial self-management of courts, as though it were the only way to do things. And that, of course, butts heads with systems even within Europe where it hasn't been the norm. So, I think preserving this knowledge about the variety of comparative design options is actually quite important.
Okay, so we have a question from MD Rabibul about the Bangladesh Constitution. I saw Ridwan here earlier, but I don't see him now. So maybe some combination of the four of you and me maybe can try to handle this one. By the 15th Amendment, the current government has changed almost 1/3 of the total constitution of Bangladesh and made the replaced provisions entrenched. How far can the present constitution survive because it has gone beyond judicial review? I think he's referring to the 15th Amendment in 2011, which was the one that Pojan and I say nice things about and Ridwan doesn't like, which is another kind of thing. But anyway, it's the one that kind of consolidates democracy. It inserts the basic structure doctrine into the text. And so the question is, a third of the Constitution has been changed. So I guess one way to ask this question is, do we have a new Constitution here? Well, Richard knows what Pojan and I have argued. We argue that it was a dismemberment, right? So something between, what do you call it, Yaniv? A fundamendment? Somewhere between a new Constitution and an amendment. But I'm curious if any of you have a view on this.
So without attempting to say anything very smart about Bangladesh, I'll just say two things. First, the fact that you have a substantive amendment and not a total replacement of the constitution title as the new constitution does not mean that substantively the constitution has not been replaced. So the basic argument that at least Gary and I make in the book, that you could have a constitutional revolution, a total replacement of the constitution through amendments. So I totally agree with this. But I just want to say that, as Sylvia said, and also Andrew in his remarks, and I think maybe even Richard, unamendability is a risky thing. It's a dangerous thing. And it conflicts with democracy. It forces people to seek other avenues for change. And the more parts of the Constitution are being regarded as unchangeable, the riskier it is and the more problematic it is. I mean, at least me, that I'm generally in favor of unamendability, I think it should be extremely limited to only the minimal core of the pillars of the constitutional order. When you protect a third of the Constitution as unamendable, that's highly problematic. I don't see any justification to that. So I would, if I would have to predict how long it would live, I cannot predict, but I think it would certainly not live too long when the winds of change, to use the Scorpions, would arrive.
Sylvia or Richard or Andrew? Oh. Does anyone else have any sort of further comments or questions? Yeah, Dave, please.
Sorry for taking dismembering the panel, but with my comment. So I just want to answer Andrew's question from his talk. He asked me about Israel, and I think it's important to say a few words because I think it shows something about the theory. So very briefly, Israel has no written constitution, no one document called the Constitution, but we have various basic laws. Each one is a chapter in the Constitution, and these basic laws have a constitutional status. Now, the basic claim that we have so far in Israel, promoted by Aaron Barak and echoed by the president of our Supreme Court, is that we cannot adopt the Indian basic structure doctrine because there is no basic structure. There is no yet a full constitution. The constitution making process is not yet complete, so we cannot adopt an Indian basic structure doctrine. Now, I find this argument highly problematic. The fact that a building is still being constructed does not mean that it doesn't have any bases or pillars. The fact that a tree is still growing does not mean that it has no roots. And a young person, even though he's young, he still has some features of identity, certain features of identity. So I think perhaps we cannot adopt a complete doctrine as the Indian one, but we can still say that there are certain fundamental values of the country that are unchangeable. Thank you.
Thank you. Any final comments? Otherwise, we can move to kind of practicalities going forward. All right, practicalities it is. Let me share my screen. I'll just make a couple of observations and then I'll talk about this. So the first observation is, I think we're delighted with the papers. Both Son and I had talked about how much we think the papers are original and interesting, and we think the book, therefore, will be original and interesting. But a lot of authors have said to us that the drafts are still in a pretty preliminary stage, and they want, and quite a few of them want to do quite a substantive revision already. So I think what we're going to do is, I don't think we are going to, as editors, going to comment on the chapters yet. I think we'll ask the country study authors to please give us your chapters by the 15th of January 2021. That was the original deadline we had. And obviously email us if there are any issues about that. For the commentators, we thought we could give you guys another month since you've just seen the papers. Full drafts, 15th February 2021. Surya Deva's paper is coming soon. He's been totally swamped. He had a business and human rights conference, and they're actually moving buildings at CityU. So his office has changed. So that's the final paper to come in, and it'll come in mid to late December. So with that, you'll have the full complement of papers to rely on. He had to go early, by the way. He sends his regrets. Son and I will get our introduction out by the 15th of March. Trying to keep this very systematic here. And so, any comments you guys have on the introductions, or what, if there's something in the introduction that you want to work into your chapter, that can be done. We're going to ask for final drafts on the 1st of May. And then we've agreed with Rutledge that we'll submit the book on the 1st of June. So if we can try to get all the chapters by the 1st of May, that would be very helpful, so that we can do a final check, put everything together, etc. Couple of final things. The first, some of you have asked about this. All the sessions have been recorded. So if you haven't been able to catch them, you'll be able to catch them later. It'll take us a little while, it'll take the IT folks a little while to edit and put them on our website. The moment they're up, I'll send you all an email to let you know. It should be a few days. The towering editors. The second thing, thank you for that. The second thing is, now you made me lose my train of thought, Yanni. What was I gonna say? Video. Oh, style guide. Son and I will send around an email with the details of the style and word count and all of that early next week. Son, do you have any final thoughts or comments?
Yes, first of all, thank you everyone, especially our commentators in this panel for very wonderful presentations and provocative presentations that we just, as editors, we just ask whether you have any other suggestions or comments on the overall project, this overall project or not. Not the practical issue, but also the overall things of the project. Another point is that, especially in your chapters, from what I heard from these presentations, is that there seem to be new dimensions, new topics, new things to do research on this topic, unconstitutional constitutional amendments. For example, the transnational dimension, or Richard also mentioned on unconstitutional constitution. So please anticipate all the topics that we need to take this issue further. For example, maybe the external dimension of things. For example, unamendability might send some signal to the outside world, to the global community, not necessarily for domestic audience, something like that. Like Cuban, for example, they make socialism unamendable, not only to talk to the Cuban people, but also to the liberal community. So maybe some new topics you can anticipate for this. This would be very wonderful for this one. So that is some of comments. So please.
Great, thank you, Son. With that, I think we'll conclude. Let me join Richard in thanking Bonnie Lung, who's done a lot of work putting this together. Let me thank our research associate at the Center for Comparative and Transnational Law, Dini Seiko, who's been keeping time and has been sending you messages that you've been ignoring. Just kidding. Let me thank the IT staff, the other admin staff that have helped us. And again, thank you all to the contributors. Great papers, great questions. We're thrilled and really looking forward to continuing these conversations and to seeing the book in print, hopefully within the next year or so. So thank you all very much.
Thank you.